Hi, my name is Morgan Blevins, and my assigned topic is to go over guardianship. So, guardianship is a legal mechanism by which the state delegates authority over an individual's person or estate to another party. And most states differentiate guardianship of one's person and guardianship of one's estate. So, there are two types of guardianship. There's general or plenary guardianship, which gives complete control over the person, the estate, or both. And then there's specific or limited guardianship, which means that the control is limited to specific decisions regarding the person or the estate. And so, for example, a guardian might have power to make a decision for a specific treatment, for a non routine treatment, or for setting a maximum spending limit. And since the late 1980s, most states have reformed guardianship processes in an effort to move towards more rigorous and fair practices. So, our textbook highlights a few of these, and this includes the implementation of the least restrictive alternative requirement, restriction of emergency guardianship, encouragement of proposed ward presence at hearings, and assurance that capacity evaluations include assessment of functioning. So the use of limited guardianship, it's not used very often, and there are a few reasons why. There are vague statutes, biases of judges, lack of resources, and respondents and their experts might not provide specific information regarding limitations. So, while ignoring limited guardianship options can lead to derogation of individual autonomy, there are also some drawbacks when they're used, such as broadening of guardianship jurisdiction beyond those with serious mental and functional impairments. So, if we want to avoid those issues with limited guardianship, the textbook suggests a few alternatives. So, first, advanced directives, which we'll talk more about a little later, but these aren't used very often. There's supportive decision making, which aims to maximize involvement of ward in decision making, but these are also not used very often. There's also adult protective services programs, which are legislatively mandated and focus on health and social services, but they're often associated with elder abuse. So, basis of guardianship. An individual can be found to lack capacities on the basis of evidence. This is referred to as de facto incompetence, which means the individual is actually incompetent, and most cases use this. An individual can also be presumed to need a guardian, whether they actually lack capacities or not. This is de jure incompetence. And some examples of this are minors and civilly committed adults are presumed incompetent and to need a guardian. So, issues in guardian context include determining the need for guardianship, determining who the guardian will be, and determining what the guardian will do. So, when determining the need for guardianship, there are some legal requirements for de jure incompetence. So, again, this is somebody who is presumed to need a guardian. So, typically, you simply just need to know the individual's age to see if they're a minor or if they're civilly committed. Because it's so simple, guardianship proceedings are typically uncommon with this type of incompetence. Looking at de facto incompetence, though, there are a few legal requirements to keep in mind. So, in most jurisdictions, anyone can be a petitioner, which means that they might not have the ward's best interest in mind. And there's also a lack of procedural rigor for guardianship proceedings. This is a common and consistent finding among several studies. And many courts endorse this situation due to the belief that consequences of guardianship proceedings are not as weighty as others. And it's also important to note that the burden to bring about restoration proceedings is on the incompetent person. And there's a lack of monitoring guardians, and both of these things often mean that restoration hearings don't end up happening. So there's also the issue of ambiguity of standards. So statutes regarding guardianship are often open to interpretation and or arbitrary decisions. So many only require findings of a threshold status such as mental illness and incapacity to care properly for oneself or one's estate. There have been attempts to fix such issues such as the Uniform Probate Code and In re Boyer, but even these standards may lead to value judgments. So, statutes are also applied with variation. Some courts rely on just medical opinion or what appears to be reasonable, whereas some courts require evidence to prove incompetence. So, looking at clinical evaluations, this is not a requirement in most states, but most states must provide a clinical evaluation if it is asked for. So, some important considerations for clinicians when conducting evaluations: loss of decisional autonomy can have psychological consequences that impact mental and physical health. Assessment should focus on the range of functions that a respondent can perform and should identify and describe in detail the tasks the individuals can and cannot perform. It should also address if the difficulties are or can be reduced with assistance and be aware of less restrictive alternatives, and they should also keep up with new strategies when it comes to evaluations. Determining an individual's capabilities is a complex cross-disciplinary process that ideally involves a range of professionals. So our textbook highlights two specific instruments, including the direct assessment of functional status and the assessment of capacity for everyday decision making. These are just two of many. The textbook actually points out a few issues that can arise with so many choices. It can be difficult for examiners to know all the options and develop expertise. Most don't have a high level of confidence, so they don't meet the general acceptance. And those that do meet the general acceptance don't necessarily assess the relevant skills or functioning that they need to. So, determining who should be the guardian. There are various kinds of guardians, including family, government agencies, social workers, lawyers, sheriffs, and even clinicians, unless they're treating the individual. So there's a few pros and cons to each of these. For public guardians, they're typically free or it's just a really small fee, but they might be impersonal, overly casual, or they might be overwhelmed with a large caseload. Family will most likely be more personal, or it could be, but there could also be conflicts of interest. So typically, mental health professionals don't have any input in this decision unless a conflict arises. So, an example would be they might help match an incompetent person with an individual who's the most likely to meet their needs and best interest. So, determining what the guardian will do. So, our textbook describes two decision making models, the first being an objective test, which questions what action will most effectively serve the ward's best interest. The second is a subjective substituted, in which the guardian acts as they believe the ward would have if they were competent. So, for mental health treatment, the best interest model is most common. And mental health professionals might conduct evaluations that are treatment oriented assessments to help the guardian make an informed decision. So, what the guardian will do. There's also advanced directives. So, this is an instruction from a competent individual that directs or authorizes certain actions if the individual becomes unable to make decisions about them, and it's used to protect individual autonomy. The textbook mentions a living will and the durable power of attorney, which both allow an individual to make decisions about what they want to happen if they are deemed incompetent. And here's my discussion question. What policies or procedures could be put in place to hold guardians accountable and help protect boards? And this is my reference. Thank you.